What law governs marriage in the Philippines? Marriage is governed by Executive Order Number 209, otherwise known as the Family Code of the Philippines. Now, what is marriage? Article 1 of the Family Code provides that marriage is a special contract of permanent union between a man and a woman entered into in accordance with law for the establishment of conjugal and family life. It is the foundation of the family and an inviolable social institution whose nature, consequences, and incidents are governed by law and not subject to stipulation, except that marriage settlements may fix the property relations during the marriage within the limits provided by this code. What are the essential requisites of marriage? Article 2 provides that no marriage shall be valid unless these essential requisites are present. 1. Legal capacity of the contracting parties, who must be a male and a female, and 2. Consent freely given in the presence of the solemnizing officer. Legal capacity is laid down in Article 5 of the Family Code, which provides that any male or female of the age of 18 years or upwards, not under any of the impediments mentioned in Articles 37 and 38, may contract marriage. Article 37 provides that marriages between the following are incestuous and void from the beginning, whether relationship between the parties be legitimate or illegitimate. 1. Between ascendants and descendants of any degree. 2. Between brothers and sisters, whether of the full or half-blood. Article 38 provides that the following marriages shall be void from the beginning for reasons of public policy. 1. Between collateral blood relatives, whether legitimate or illegitimate, up to the fourth civil degree. 2. Between step-parents and step-children. 3. Between parents-in-law and children-in-law. 4. Between the adopting parent and the adopted child. 5. Between the surviving spouse of the adopting parent and the adopted child. 6. Between the surviving spouse of the adopted child and the adopter. 7. Between an adopted child and a legitimate child of the adopter. 8. Between the adopted children of the same adopter. And 9. Between parties where one, with the intention to marry the other, killed that other person's spouse or his or her own spouse. The second essential requisite of marriage is consent of the contracting parties. Under Article 2 of the Family Code, for consent to be valid, it must be 1. Freely given, and 2. Made in the presence of a solemnizing officer. A freely given consent requires that the contracting parties willingly and deliberately enter into the marriage. Consent must be real in the sense that it is not vitiated nor rendered defective by any of the vices of consent under Article 45 and 46 of the Family Code, such as fraud, force, intimidation, and undue influence. Consent must also be conscious or intelligent, in that the parties must be capable of intelligently understanding the nature of and both the beneficial or unfavorable consequences of their act. Their understanding should not be affected by insanity, intoxication, drugs, or hypnotism. This was explained by the Supreme Court in Republic v. Liberty de Albios, GR number 198780, October 16, 2013. Now, what are the formal requisites of marriage? Article 3 of the Family Code provides that the formal requisites of marriage are 1. Authority of the solemnizing officer. 2. A valid marriage license, except in the cases provided for in Chapter 2 of this title. And 3. A marriage ceremony which takes place with the appearance of the contracting parties before the solemnizing officer and their personal declaration that they take each other as husband and wife in the presence of not less than 2 witnesses of legal age. Now, what happens when any of the essential or formal requisites is absent? Under Article 4 of the Family Code, The absence of any of the essential or formal requisites shall render the marriage void ab initio, except as stated in Article 35, Paragraph 2. A defect in any of the essential requisites shall render the marriage voidable as provided in Article 45. An irregularity in the formal requisites shall not affect the validity of the marriage, but the party or parties responsible for the irregularity shall be civilly, criminally, and administratively liable.